about the consumer demand, the steep hockey stick that is driving the build out of these networks and making sure that the infrastructure is where it needs to be, closer to the user, and provides additional capacity and coverage. We've learned quite a bit about how to pay for that network. How do we outlay the costs and get folks to use the network to pay for it? We've learned a lot about shared infrastructure there. And we've also looked quite a bit at the engineering aspects. What goes into a good RF design? How do you work with your in-building communities and work to put together a contract that is appropriate and gets the best coverage possible? And we've learned about some of the applications. We've learned about public safety in detail in one of our panels earlier in the week, and we've even heard little tidbits about what Boingo is doing with tracking customers within buildings and looking at the showcasing effect at different big box stores. So, it's pretty great that we come off of Ian's presentation now of what's to come in the market that we're in. And throughout the last couple of days, we've heard a little bit about the regulations that affect these devices. We've heard the costs associated with it. But here we have the opportunity to dig into that a little deeper. So let me introduce my panel here. To my immediate right, we have Scott Thompson. Scott lobbies, negotiates, and litigates on behalf of the telecom industry clients before the FCC and state public service commissions, local governments, and courts. Some of his clients have included Comcast, NextG, the New England Cable Telecommunications Association, and T-Mobile. Scott's also been on the DAS Forum's advocacy committee for a number of years. To Scott's right is Chris Olds of Pennington Law Firm. Chris's primary practice area is in the representation of wireless communications carriers and the related industries. His work involves the many legal components associated with the organized deployment of wireless infrastructure, and he works quite a bit on the contracts that are negotiated for in-building and outdoor systems, and has recently successfully put together a master agreement for a university. Maybe we'll learn a little bit more about that. And to Chris's right is Chris Hills of Stealth Concealment Solutions. Chris has been in the wireless industry since 1996 and at Stealth for over 12 years. He's a highly knowledgeable expert in the Western region sales force, sales rep, and possesses a strong combination of what goes into antenna concealment and design, and based on his customers, knows quite a bit about the feedback that you're all getting in the field. So without further ado, this is the panel we have, and we look forward to your questions at the end, but I'll hand it over to Scott.
Sorry if I stand up.
Yes.
Sure.
I can't see you from the camera.
Okay.
Thank you.
So is this thing working? We need to get that.
Man, if he has slides.
So I promised to make this interesting, and in keeping with the tenets of good use of PowerPoint, I do have pictures, and pictures in the use of regulatory. So let's. We'll see if we can get those up there. Or not. Zach has hidden them on the computer apparently. So I'm going to give a quick overview while they're pulling that up. So I'm going to address some of the high-level overview of the regulatory issues facing DAS and small cells. Some of these are not new by any stretch, but I am going to address some of the more recent developments on a federal level that are going on. I've broken this down into really 4 levels that any deployment of DAS or small cells has to think about. The first is a state level. Then there's also in outdoor DAS, you've got pole attachments that I think merits its own topic. Then you've got a local regulatory level, and then overarching all of it is federal issues. And so I'm going to run through those, and while they're pulling that up. So on a state level, and this is primarily, this discussion, I'm primarily going to be talking about outdoor DAS, but it is something that also would apply in many instances to indoor DAS, and depending on how they're done, possibly small cells, depending on who does them and how they're done. So, at a high level and a state level, most outdoor DAS providers are getting state-level regulatory approval. Technically, they are wireline transport carriers from point to point. They're providing what on a traditional state level would be viewed as a point-to-point direct line service. Private line service might be called, depending on the state. And so most of them have gotten state-level certification. That brings with it some advantages. When we're going into cities, trying to deploy in the public rights-of-way, cities are going to say, well, where's your approval from the state that says that you're a certified carrier? It also brings with it some credibility when you're dealing with for pole attachments. When you go to a utility, they're similarly, even though technically this isn't correct, they're all going to ask, well, where's your certificate of public convenience and necessity proving that you are a telecom provider? Are there regulatory burdens? There are. I would say that on the whole, they're not overly burdensome. There's some record keeping that needs to be kept track of. There are companies out there that are consultants that can help companies with those types of things, just making sure that certain reporting gets done on a timely basis. So it's not a terrible thing. Pole attachments, there could be an entire, and there have been at other DAS forum events, there have been entire panels on pole attachments. So I'm going to touch on this very briefly. Obviously, this is an issue for outdoor deployments. Jonathan Allison mentioned it yesterday. So in 1978, Congress enacted provision in the Communications Act that addresses the rates and regulations for attachment to utility poles. That has been amended over time, and at this point it is clear that that applies to wireless attachments. In 2011, the FCC adopted a new order. PCIA was very involved in this, as well as other members of the DAS forum individually. And in that order, it clarified a couple of key things. It clarified that wireless attachments have a right to access the top of the poles. Clarified that wireless attachments are subject to regulated rates. This is a big thing. I've been in discussions, and I know for a fact that historically utility companies were trying to charge DAS providers in the neighborhood of thousands of dollars per year for pole attachments, where the regulated rate would be like $30 or $40. And a lot of people didn't even realize that they were entitled to that. So that is been clarified now. A nice piece of the 2011 pole attachment order is the FCC changed its rules so that if you've been overpaying, you can get refunds if you bring a complaint. And the FCC also set out a timeline for make-ready work and applications. Again, all this could be a topic of an entire panel. So that was a very important development recently at the FCC. From what I understand and from what we've encountered, I think that the pole attachment order has been helpful. It's working. There are a lot fewer upfront problems with utility companies who own poles. I mean, 5 years ago, we would have had a panel where it was all about trying to talk about the problems, simply getting them to talk to you at all. So hopefully we're past that hurdle and we're into more sophisticated discussions. So for outdoor DAS, the next level of regulatory issues at a local level, and obviously I'm skimming through all of this. Zach, you might use my computer? Okay. Because I want those pictures when we get to them. So on a local level, oh, here we go. Let me skip forward. So where are we? Does this thing work? Where do I point it? There we go. So let's see, where have I been? I have state level issues, pole attachment issues. One thing I didn't mention, So generally, the FCC has authority over pole attachments, but under the statute, states can take back authority, and there have been, and that's wrong. It's 20. That's, I thought I'd updated that. There are 20 states, and the District of Columbia have quote unquote certified that they now regulate pole attachments. So FCC rules don't apply there, although in the vast majority of those states, the states absolutely look to the FCC's rules, and in many of them have simply adopted the FCC's, particularly their rate regulation wholesale. So rights of way. So now we're getting down into the local level. This is obviously a big issue. This is something that Ian just mentioned. You know, how are we going to deploy these things? And I'm going to try to talk about both outdoor DAS and indoor DAS, and I'm ultimately setting up what will be a little discussion at the end about should any of this apply. So if you're deploying a DAS in a public right-of-way, the traditional mechanisms for people deploying facilities in the public rights-of-way were somewhat varied. Cable operators had to get franchises, but that was really authorized by federal law. If you were to have asked, and I've got a partner who had worked, he worked at, well, at the time it was not even Bell Atlantic, it was C&P Telephone, before 1996 Act. You know, when he joined us, I said, did you guys ever get local franchise? He's like, no, right? The ILECs, on the whole, nationwide, deployed telephone networks around their states with essentially little or no local authority whatsoever, right? Some of them have statewide grants from like 1870 that say you're allowed to go into the right of way, and the cities, some of the cities don't even require them to get permits. Even now, all right, the city of San Francisco does not require a site-specific permit for the wireline ILEC to deploy boxes on existing utility poles, okay? However, you know, if you mention wireless, we're now, DAS providers, wireless providers are being treated differently, and this is all a big setup. But so you're going to go into cities, and despite the fact that historically they've not required much, they are now requiring a lot more. Franchises in some instances, those may or may not be allowed under state law. There are some limits on what they're allowed to do whoops, I went backwards. Now I'm going backwards, sorry. There we go, state. So there are some limits on what cities can require. There's a federal law limitation. Section 253 of the Communications Act says that cities can't enact regulations that have the effect of prohibiting your ability to provide service. This has been addressed by a number of courts, and candidly, the trend has been less industry friendly over the past 5 years. It has become a more difficult showing to make, but it's still one that can be made. If you have a city that out and out says no and denies your permits for an entire network, that would quite clearly be a 253A violation. The Act reserves for cities the right to manage the rights of way, but to do that, it has to be in a competitively neutral and non-discriminatory manner, which brings us back to my point, which was they don't require any of these types of things for other rights of way occupants. State laws also come into play. There are a lot of state laws that grant telecommunications providers, which would include DAS providers, outdoor DAS providers, the right to occupy the public rights of way. So that's a source of access to the right of way. Some states also have statutes that limit the fees that cities can charge for access to the rights of way. Those are fairly important because in a lot of states, maybe they don't have any problem with you accessing the right of way, but they want a big chunk of change antenna on a utility pole in a public right-of-way. And it's a lot of times it's something you have to look at. Does it? A lot of them were written in a way that they don't. A lot of them are written very broadly in such a way that they apply to, theoretically, any antenna. So that's something that has to be looked at. I would submit that companies need to, once they've, even if the ordinance applies, you should look at whether or not the ordinance is lawful. Again, is it a barrier to entry? I've run across cities, and I know they're out there, that effectively prohibit wireless antennas in the public right-of-way. Well, that is effectively prohibiting a company from providing a DAS network. So that's an argument that's out there. Number 3 is the big question that I'm going to sort of draw at the end, and that is, should the local ordinance apply or be legal? Should the cities be applying these things to, and should cities be applying these regulations to small antennas, small utilities, small equipment boxes that are being placed on poles in the right-of-way, along with other equipment that's quite the same but is treated differently? So keep that in mind. Federal issues that are hot right now, obviously here, I guess it was just earlier this year. No, it was last year. It was last year, sorry. Middle class, Congress passed as part of a larger package, part of the Middle Class Tax Relief Act from last year, Section 6409, and this is at times been referred to as the collocation by Wright provision. It says that a city shall grant and cannot deny a eligible facilities request to modify an existing tower or base station, and if it does not substantially change the physical dimensions of the tower or base station. That raises a whole host of issues. It could be its own panel in and of itself. I will identify a couple of the key ones. One of the real big ones for small cells and DAS deployments is whether or not they fit within that definition of base station or tower. With some help from PCIA, let me back up shortly. The FCC ultimately had definitions on the books that made it clear that a base station was very broad and would include a DAS or small cell. Nonetheless, cities were fighting that, I think, a little bit, or were not aware of it. And so in January of this year, the Wireless Bureau of the FCC issued a very nice public notice. PCIA was involved in, I believe, in probably prompting this, in which they clarified that, based on the existing definitions, that in fact a base station in that definition, whoops, didn't mean to do that. A base station in that definition does include DAS or small cells. I think that the public notice has been helpful. I think that I know for a fact that from a case that I'm involved in, that there are still cities who refuse to take the position, well, that was a public notice, it's not a binding precedent, et cetera, et cetera. We do know that this is still an issue, and I'll mention more in a bit. Oh, good Lord, I'm going please forward. There we go. Another big issue that's sort of hot in federal circles at this point is the application of the National Historic Preservation Act to DAS and small cells. Something that didn't get a lot of attention, I think, in the first 5 or 6, 7 years of DAS deployment is the prospect that as you are putting these antennas and equipment on, like, utility poles in particular, to a lesser degree, but also possibly in buildings, that they may be in historic districts. Zach has a very interesting story. So just by background, there's a national programmatic agreement, there's a national programmatic agreement on collocation, and under those, you would be excluded from historic review if you're on structures that are 45, unless the structures are 45 years or older or in historic districts. Well, as it turns out, and I'm really surprised to hear this, the lifespan of a utility pole apparently can be more than 45 years. Zach was telling me that somebody ran across a utility pole that's more than 45 years, and so suddenly attachment to this utility pole involves attachment to a potentially historic structure and could trigger historic review, Section 106 review, which is, I'm not even going to go into, quite burdensome prospect. There are moves afoot to try to change this. PCIA earlier this year submitted to the FCC a white paper done by Amos Loveday, who's a well-known historic preservation expert, addressing this issue and asking the FCC to take some action to include DAS and small cells in exclusions from historic review. There are a couple of different ways to do it. I think the most common one, that the first one certainly that PCIA has asked for, is to have it treated as an exclusion under the existing regulations. The FCC in its 2004 order adopting the National Programmatic Agreement, the NPA, it already suggested this. In paragraph 63, they talked about how exclusion should go to certain construction in or near communications and utilities rights-of-way. Amos Loveday addresses this in the paper. Ultimately, the language of the NPA is not as broad as the language the Commission used in the report and order. So this, PCIA has asked for the Commission to clarify that, perhaps use it as a stepping-off point to go ahead and, via a rulemaking, make it a definitive exclusion. So the press, there's been some reports in the press that the FCC likely is going to move forward with a notice of proposed rulemaking on these issues, the Section 106 historic review issues, also potentially adopting rules addressing the applicability of Section 6409 of the Tax Relief Act, making that a firm rule as opposed to via just a public notice. So those would be positive developments, and those are moving forward. So the last bit, I was talking with Zach and preparing for this, and we decided we should, a lot of this comes down to why would wireless installations, small cells, DAS installations on a utility pole, on a streetlight pole, so let's stick to those for ease of discussion. Why are they triggering full-blown zoning review? Why are they triggering potential historic preservation review? When, like I said, the other utility equipment that's out there, I'm going to say doesn't. I know there are a few places that they do, but for the most part, it doesn't. Okay? So this is what we're going to see out there, right? You've got a utility pole that is 45 feet tall. This one's probably taller than that. It's got electric cross arms up at the top, right? That's probably 4 feet on either direction. You've got electric transformers. Those are a solid, 2.5 feet tall, a solid foot in diameter at least. And then you've got this, you've got an antenna that you can barely see, but that antenna is subject to all sorts of review that none of this was, none of these wires. Got another example up here. So another same thing, right? This is a more rural, urban setting. You've got, like I said, more cross arms. Back here is a cable television box, typical. I mean, there's one up the street from my house like that, right? It's the same size as this wireless box. I assure you that all these cross arms, this electrical equipment, this cable television box, didn't go through a discretionary zoning review when they put that up there, right? It's just not heard of. It's only because this thing emits radio frequency waves that it's triggering this. Last but not least, this, people like this one. This is my son. That is a Verizon Fios box that's up the street from my house. My son is no longer that size. He's now 6 feet tall, but this was a few years ago. But that's, that gives you some scale. So this thing is at least 4 foot tall Fios box. They didn't go through zoning before they put those all over the neighborhoods. I live in Arlington, Virginia. These are nice houses behind them. So the question, and I assure you, it didn't have to go through historic review and stuff like that. They just went out there and put them up. In fact, they put them up, and in some places around the country, the cities got angry, and they maybe had to go back and say we're sorry. But for the most part, they just put them up there. So there's a very legitimate policy argument that says that these devices, simply because they radiate RF, should not be treated any differently than all of this other stuff that's out there, right? There's no greater impact from these simply because it radiates RF. And so that's a big underlying part of what the arguments on both the historic review, the collocation by Wright provisions, but there's still issues that we run into, and I would suggest that from a policy standpoint, those are the things that should be driving us, not the fact that the equipment emits RF. And now I'll turn it over to Zach and the rest of the panel. That's the big overview. I can take questions later.
Great. Well, thank you. You've addressed a very complicated matter, and you've summarized it in such a way that I think many of you can appreciate the differences. So thank you. Chris, we'll turn it over to you. Maybe talk a little bit about what you're doing with in-building and the contracts that you're working there, and what you see as far as what goes into those agreements.
Sure. My name is Chris Olds. I'm with Pennington Law Firm. We're based in Columbia, South Carolina. I am admittedly not much of a regulatory guy. My current role has me more in the role of just being contract guy. So the one regulatory note I will throw out there is if your regulatory department is not your contract department, make sure that those two are communicating, because you don't want a regulatory issue to cause some kind of hiccup and then that not be communicated, and and maybe it's something that can be addressed somewhat in your contract. You just want to make sure that everyone's on the same page. Anyway, currently, my current role, I'm primarily negotiating these agreements on behalf of carriers. Our firm does some work on behalf of, the other players in the industry, but, personally, I'm dealing more on the carrier side. I'm not, this is, the things I'm going to go through are more from my personal experience, not so much, any specific carrier's position on anything. Obviously, the first big thing is, the system model, whenever we're coming to negotiate these types of deals, who's going to own the system? Is it going to be carrier owned? Is it going to be neutral host owned, third party owned, or is, the property owner, the building owner going to own the system? Obviously, if the carrier owns it, there are some concerns that, maybe they may be concerns in the other scenarios. They're not going to be a concern, if the carrier itself is going to own the system, like the retransmission piece, the maintenance piece, that kind of thing. And then, of course, there's the multi-carrier versus single carrier issue, which, based on what most of the carriers are saying, at this conference, it sounds like we're going to more of a multi-carrier approach. But, there's been a lot of single carrier systems that I've worked on in the past few years. But I guess as far as the common issues that we're running into, on the legal side, there's always going to be the indemnity and the insurance and the limitation of liability and all that fun stuff that most of the business folks just like to turn away from and just let the lawyers duke out. It's funny, the biggest issues that we've been running into are probably the business issues. It's really kind of surprising, how many times I'll get a draft agreement and the business, there's really no conceptual agreement as to how the business deal is going to look. Sometimes system ownership is really kind of up in the air. But anyway, the probably the one big issue that's been coming up more and more recently is the cost. And obviously, as you've heard throughout the conference, the costs are just getting huge as far as doing these stadium deals, these outdoor DAS deals. And a part of where the system is going to be is kind of going to dictate, I guess, what the player's position regarding cost is going to be. If it's a building or a venue like an outdoor stadium, maybe the venue owner is going to be willing to contribute something for that system just based on the fact that they're willing to go ahead and pay a price for their customers to have that whole full experience. Whereas if it's just a typical outdoor DAS where you're just trying to bring coverage to places where maybe your macro network hasn't been able to cover, like the French Quarter. My experience has been, those are more carrier driven, and that's not always the case, but typically it is. One exception I found to that rule, though, is with some universities. And it's kind of funny, I've worked on a university deal recently where, and this will give you an idea as to how far apart the parties are sometimes whenever we're working on these deals. The university, approached the carrier and essentially said, hey, look, we've got this plan. we want this full campus dash, and we want to cover the stadium, we want to cover the academic buildings, residence halls, the whole deal. We're going to roll it out in phases. Right now, phase 1 we think is going to cover this part of campus, but in the future, we're going to cover everything. So, okay, great. Well, who's going to pay for it? Well, you are, carrier. Okay, well, do you have a design in place? No, we've got an idea of how we want the system to look, but there's no firm design. And I mean, the carrier's obvious response was, well, no. I mean, we're not going to write you a blank check, which was essentially what the university was asking for. I think the big takeaway from that is, I mean, be reasonable when you're coming to the table on these issues, because I mean, I guess it's okay to shoot for the moon, but at the end of the day, if you want to get the deal done, I mean, all the parties involved, I mean, they're going to have a vested interest in these systems getting built and having that enhanced coverage. So just work together and try to come up with a solution. And there's been some pretty creative solutions that we've seen recently as far as cost contributions, and sometimes I know we're trying to get away from the whole rent piece, but sometimes maybe that's thrown into the mix if you have a lower upfront cost just to get the overall cost of the system down. Yeah, collaboration is key, and not just amongst the original parties to the deal. If you've got a system that's going to be on a university campus, for instance, and it's initially just one carrier that's working on the deal, go ahead and reach out to some of the other carriers and just see if there's any interest there. Because maybe if it's the kind of system that one carrier alone wouldn't be able to fund, split 2 or 3 ways, maybe it's a lot more doable. So just, consider those things, because I know those are the kinds of deals that pop up all the time. And on that same token, it's particularly in the neutral host environment. If you're a carrier, you're contracting with a neutral host, or I'm sorry, if it's going to be like a venue owner or property owner owned system. Say, a carrier goes to the property owner, and they're just going to fund the entire thing up front. But it's going to be a multi-carrier system. There's a possibility that other carriers are going to join in the future. Those other carriers, obviously, they're going to have to make some kind of capital contribution to join the system. Well, if you're carrier 1, you need to make sure that your deal with the property owner says, okay, property owner, once you get that capital contribution, you need to pass it on to us so that we get reimbursed for a part of our initial investment. Because, if the 2 carriers don't have any kind of contractual privity, there may not be a lot of recourse if you can't look directly to your property owner for that. Aside from the cost issues, which we've talked about a lot, aesthetic issues, anything regarding appearance, property owners are always going to have concerns about. And with the university sites, a lot of times, the carrier has a macro site that's, close by, maybe off campus or maybe even somewhere on campus. And they can go ahead and put their base station equipment there, so you don't really have to worry about the BTS space. In other scenarios, though, I mean, maybe you have to put a shelter out there, and there's going to be a lot of situations where, maybe the university, they don't want just your run-of-the-mill, prefabricated building out there. They want something that's a little more aesthetically pleasing. And we've worked on one recently where this building was going to go in the middle of campus. All the surrounding academic buildings, they all look a particular way. They're all similar architecture. They're all similar stonework. So we had to take those elements and incorporate them into, the way that the base station building the BTS building was going to look. So, and of course, when you have to do something like that, that's going to drive up your costs. So, all that factors in. It just goes back to that cost piece. So, just something to keep in mind. Other components that we run into all the time is, the maintenance piece. And like I said, I mean, if it's going to be an owner or a carrier-owned system, maybe that's not as big of a deal, particularly in the single carrier scenario. But if the property owner, the building owner is going to own the system, or if you're going to have a neutral host, there's going to be a lot of language in the agreement about, who's responsible for maintenance, who's responsible for purchasing the spare parts and deploying them in the event that, you do have some kind of system failure and that has to be addressed. Access is always another issue. And particularly, university campuses, a lot of times they're going to have policies and procedures as to the steps you have to take to get access to campus. And if it's available, I mean, go ahead and, take a copy of those procedures and just attach them to your agreement as an exhibit. I mean, that way at least you've got everything incorporated. You can refer to it. Everyone's on the same page as far as what the requirements are going to be. And that way when you have an emergency pop up, you need to get to, to campus to go ahead and address it. You don't have any surprises pop up. Hospitals are, another kind of venue where access can be an issue. And, I think at the end of the day, as long as the carriers have 24/7 emergency access, they're able to get in there in the event something goes wrong with the system that they need to address. It's been my experience, they're good with that. If they have to go through some additional notice requirements or something, otherwise, let's just, like I said, get everyone on the same page so that everyone knows what the requirements are going to be. Interference obviously is another issue, and I'm referring to both RF interference as well as, just general interference with, guests of a venue, disruptions and things of, noise, things like that. From the RF side, particularly if you're in a, in a hotel or if you're in a hospital where, there's a lot of, medical telemetry interference issues that could pop up, you may need to come up with some specific carve-outs that can kind of address that stuff and just make sure that you do adequate testing on the front end so that you're aware that, those are going to be the limitations and that you're going to have to avoid that. Briefly just touching on the neutral host piece, like I said, I mean, there's always going to be the indemnity and the limitation liability and all that legal stuff that, we always take it always takes a little time to work through. We've always been able to work through that though and get everyone on the same page. But, the pricing structures in those can be a little overwhelming if you've not dealt with one before with the capital contribution fees and the transport fees, maintenance fees, and then you've got these, uptime objectives for how long the system is going to have to be up and on air, in any given year, and then you've got outage credits that are calculated based on the uptime, and anyway, it can just get very convoluted. So just a heads up if you're going to be working on some of those and have not to this point. But that's pretty much all I've got.
Great, thanks, Chris. And Chris Hills, I know you know a thing or two about university campuses and what goes into those. Give you the clicker here.
Do you mind if I stand?
Go for it.
How many attended the tour through the French Quarter this week? Pretty good percentage. Many of you saw this concealment. It was our entry into the DAS concealment world. I actually worked with a company called New Path Technologies back in 2006, and we designed this concealment. It was our first one. It was a very good one to cut our teeth on, given the geographical location of the DAS system, and it's, we'll call them environmental challenges. You can imagine the type of clientele that's down in the French Quarter. They took a lot of abuse. So we worked on ways to make them both durable and also very easy to access for the client to access the radios, do any upgrades, or change out any equipment problems that they may have had. Stealth has been in concealment now for about 22 years, and we worked primarily with the macro carriers, but since the emergence of DAS, we've actually done quite a few more stadium sites. Application at a university. As you can see at the top, the antennas are housed in a cylinder, a removable cylinder, and the bottom is where the radios are located. So it has a nice little access door. The radio actually falls out and can be easily removed and replaced for any maintenance issues. Here's an actual photograph of that structure. And the university held us to a pretty high standard. We actually had to match the exact pole, and that's not a round base pole. That's a it had indentions that was unique to only one manufacturer in the United States. So we had to reach out to them in order to buy that piece of pipe in order to integrate it into our design in order to match the poles that were on campus. Here's a ODAS. Well, it's actually a venue in Little Rock, Arkansas, War Memorial Stadium, where we replaced 36 of the section markers. So before we did anything, all the markers were just a piece of sheet metal painted with the sign numbers on it. So we developed these boxes that had the removable face. We put 2 sets of antennas and 2 sets of radios, RRUs, inside this box. And we did 36 of them around the stadium. We had to be very particular about matching the existing color. All paint fades, so if you come in and you didn't replace all the section numbers, you had to paint to match the faded paint that was the ones that we did not replace. So it can be challenging in times to get them to match perfectly. This is the University of Oklahoma. As you can see in the upper right-hand corner, that was an existing flagpole base, just basically mounted to that concrete column with some very robust U-bolts. Then in the next flagpole over is the actual antenna, and then as you slide on down to the left is the actual box that we made to sort of mimic the mounting apparatus of the flagpole. It later became dubbed by the university IT folks as the oil cans. So and there's an up-close photograph of that box. As you heard Scott talk about right-of-ways and municipalities fighting carriers to locate in right-of-ways. This one's in the city of Scottsdale. New Path also was working on this project. It's now Crown Castle owned. They were forced to put up these cactus in the right-of-ways. So as you can see, they're about 24 foot tall. In the very top, which is removable, they have 2 sets of antennas for 2 carriers, and all the radios are mounted inside, and it has a fan in there to help cool the radios. I've seen these cactus locate probably within 20 feet of someone's dwelling, just right out the back window. Yeah, they had good coverage, but I'm not so sure that the building owner was so happy about having a concealment that close to his home. But they concealed it, they met the demands, and were allowed to put it up. And this is also the University of Oklahoma. It's more of a side-mounted box application where the antennas are mounted in the top. The coax was pulled through the wall. They core drilled through the backside, ran the coax in, and ran it up into to the antennas in the top. And here's a finished photograph of the 2 boxes. We're right now in the midst of redoing this whole stadium, all the boxes, to add more antennas. It was only been up for 2 years, and the demand is such at the venue that they just don't have enough capacity. So they're redoing the DAS to increase, make the user experience much better. Another different type of box, the University of Mississippi, where we just added the box, as you can see, the logo and the section markers at the top. I think pretty much everyone here recognizes where this is at. Same thing, you have these stadiums that there's not really a whole lot of places to locate antennas. And if you're going to conceal them, a very good spot seems to be the vomitory, where people enter the stadium. You match the sign markers, the logos, to get them to blend in. In this stadium as well, it faces east-west, so when we put the boxes on the north side, it was a darker color red than the boxes on the south side, because the signs had been up there for about 6 years and had faded more on the south than the north. So we had to paint these 2 different colors. One of the other issues is the venues owners have is changing the look of the outside of the stadium. We did a LA Coliseum, and they thought they were going to be able to put boxes on the top, but the fact that you change the look of the outside of the stadium, you actually introduced an issue with SHPO, because they didn't want to change its appearance. So even though they owned the stadium, they were not allowed to put the antennas on the top rim in order to get the coverage they wanted. So in that case, the actual DAS system performance suffered because of the local restriction. And these are what we call a medallion. It was done at the University of Clemson. They wanted to keep the flagpoles, and the carrier wanted the height for the coverage on the top of the bowl. So we came up with this, what we call a medallion. It houses the radios and the antennas. It also allows the flag to be raised and lowered and changed out. So it was kind of a unique offering that we had not done that before, but the stadium liked it and it got approved, so it worked out very well for everyone. This is Arrowhead Stadium and the old mist box in the back. This is that's not really applicable here. But that's really most of all the ODAS systems that we've done are either universities or campuses. Most of them get installed without having to hide the antennas. Occasionally we've run into instances where they weren't really required to conceal the antennas, but it became an issue with the antennas being taken off, actually torn off by some rowdy individuals. So we've also done some boxes as a security effort to help stabilize the system and keep them from taking them down. I don't really have anything else.
We got time for like one question, and then I want to get us somewhat back on track so that the people on the If not, then thank you guys.
I have one question. It might be, yeah, moderator's privilege. So Ian said that anything not on a tower is small or is a small cell. I'd like the panel's quick opinion, so we stay on track. What do you think of that? And secondly, we don't know what a small cell is, a femto cell. All these things are up in the air. What does getting the definitions wrong in the regulatory framework mean for deploying, for selling these services and getting these things deployed?
I'm not going to give you any opinion on what is or is not a small cell, for the reason that I'm going to say that I think the industry has to be very careful about making sure that definitions adopted by regulators now are not broad enough for future deployments, because then you're going to have a real problem. I mean, we're already dealing with deploying under laws that didn't anticipate the current technology. So if you have regulators who in the best of intentions adopt something that they think are trying to help you, but 5 years from now doesn't match with the equipment at the time, it's going to be real hard to get the regulations. It's going to be much harder to change the regulations to keep up with the technology. So it's an important issue, I think.
Yeah, I'm just waiting on my clients to tell me what a small cell is. Whatever their definition is kind of what I have to go with. So.
And where does it stop, Zach? I mean, if you're allowed to enforce concealment on a macro site, are you going to allow a small cell site to not be concealed because it looks more like a cable apparatus, maybe the equipment that they would use on a utility pole? So we're going to see a lot of pushback from the communities on what they will and will not allow. I'm just not sure where it's going to end at this point.
And with that, I think we'll draw this panel to a conclusion. Thank you so much to this panel, and for a great day's event.